Chapter 3 in Crime in Evidence and Crime. Lesson 1 Evidence. The three definitions of evidence. Evidence in its legal definition is the means sanctioned by these rules of ascertaining in a judicial proceeding a truth respecting a matter of fact. Evidence also refers to any material which aims to persuade the court of the truth or probability to some fact alleged or asserted before it. Evidence refers to all means by which any alleged matter of fact whose truth is investigated at judicial trial is established or disproved. Evidence, evidence in its legal definition is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Evidence also refers to any material which ends to persuade wala bigla to ano to, persuade the court of the truth or probability to some fact alleged or asserted before it. There are three types of evidence, namely oral testimony, documentary, real, and circumstances evidence. Evidence refers to all the means by which any alleged matter of fact whose truth is investigated at judicial trial is established or disproved. Three forms of evidence in criminal investigation. Physical evidence refers to physical object used as evidence which is obtained through searches at the scene of the crime. Refers to the article and materials found in connection with investigation which aid in establishing the identity of the per- perpetrator. This may include the following: firearm and firearm munitions, knife or bolo, blood, semen, saliva, human or animal, biological samples, finger and footprints, tool marks and tire tracks, hairs, fibers, glass, paint, and other evidence, other trace evidence. Category of physical evidence. Associative evidence. These are pieces of evidence which links a person to a crime. The offender may leave clues at the scene such as weapon, tools, garments, fingerprints, or foot impression. Tracing evidence. There are evidence that may assist an investigator in locating the suspect. Aircraft of ship manifest physicians, clinic records showing medical treatment of suspect for injuries sustained in an encounter in an encounter. Bloodstains recovered from the area tra- traversed by the wounded suspect and fell in direction of the movement of examples of tracing evidence. Biological and transit evidence. Biological evidence. It refers to evidence that is commonly recovered in crime scene. Each biological evidence has a unique importance and its own probative value. Transient evidence refers to evidence that by its very nature can be easily changed or lost. For instance, transient evidence includes temperature, odor, blood in the rain, and some biological and physical phenomena. What is corpus delicti? It is a Latin term for the body of crime. It is a legal term used to describe physical or material evidence that a crime has been committed, such as corpse or murder victim and the cleaning of a touched building. Other specific kinds of physical evidence. Soil. It contains organic, natural materials such as rocks, minerals, and decomposing plant, and may also contain man-made materials such as bricks, concrete, glass, or paint. Paint. Paint is pigmented polymer that is applied and adheres to various surfaces. It is possible to examine microscopically the color of shape of paint tips or other samples as well as determine through the use of gas chromatography tool mark is any marks that is created when an instrument has contact with another surface. Shoe prints and impressions. Shoe prints are created when material from the bottom of shoes is transferred to another surface, leaving an outline of the bottom shoe. Videotape evidence. Videotape is potentially extremely powerful form evidence. If a crime captured on video, there may be little doubt about who committed the crime. Dental evidence. The two primary kinds of dental evidence are dental identification and bite marks. In both instances, the fact that an individual has a unique set of teeth in terms of form, arrangement, dental work, and bite is dental evidence powerful form of criminal evidence. Computer and other electronic evidence. Computers, computers, cellular phones, and other personal digital assistants may provide a wealth of information regarding communications, schedules, and criminal behavior, and therefore are potentially valuable source of evidence in crime investigations. Testimonial evidence. Testimonial evidence is also known as eyewitness testimony or communicative evidence. It is a product of interview and interrogation from which witness smell, hear, taste, and touch are being described through oral and written testimony. Kinds of testimonial evidence. Ordinary witness. Any persons who perceived the commissions of crime and testified before the court is just considered as an ordinary witness. Expert witness. A person whose testimony concerning in the investigation of a crime is based on his training and experience. Hence, a physician who confirmed before the court the cause of death of a victim is considered as an expert witness. Who is a witness? A person who testifies under the oath of the trial in a trial or a disposition. In the lawsuit, plaintiff or defendant may be a witness. What is a deposition? It is a testimony taken orally with the attorney asking questions and the deponent, the individual, answering while a court reporter or tape recorder records testimony. Documentary evidence it refers to writings, including official records or contents that could speak for themselves when read by the investigators and other courts. Birth and death certificates. Ability to establish. Lesson 2 Legal classifications of evidence. Ability to establish a fact in dispute of an evidence. Direct evidence it is that which proves the fact that dispute without the aid of any inference or presumption. Circumstantial evidence. The proof of fact or facts from which taken either singly or collectively. Existence of particular fact is dispute may be inferred as a necessary or probable consequence. There is more than one circumstance. The fact from which inference are derived or proven. Degree of value establishing a disputed fact of an evidence. Prima facie evidence. Evidence offices for the proof of a particular fact contradicted other evidence. Conclusive evidence. This evidence is incon- incontrovertible incontrovertible or one which the law does not allow to be contradicted. It is insurmountable evidence. Corroborative evidence is evidence is a different kind of character, as it already given and tends to prove the same proposition. Cumulative evidence. This evidence is of the same kind and character as that already given to tend to prove the same disposition proposition. Weight and acceptability and acceptability of an evidence, primary or best evidence. This evidence afford the greatest certainty of the fact question. Secondary or substitutionary evidence. This evidence inferior to primary evidence and admissible only in absence the latter. The nature of evidence. Object evidence. This evidence is addressed senses of the court and is capable of being exhibited to the examined or viewed by the court. It is also known as autoptic evidence or real evidence. Documentary evidence refers to the evidence supplied, the written instrument or derived from conventional symbols and letters by which ideas are represented from material substances. Testimonial evidence. The evidence is either verbal or oral. It is an evidence which consists of narration or disposition by one who has observed or has personal knowledge of that to which he is testifying. Positive evidence. Evidence exists if the witness affirms the fact did or did not occur. It is entitled to greater weight since the witness presented his personal knowledge about the presence of a fact. Negative evidence. This evidence exists if the witness states that he did not see or know of the occurrence of a fact, and here is a total disclaimer of personal knowledge. Relevant evidence. Evidence is relevant if it has relation to the fact in issue as to beliefs in its existence or non-existence. Material evidence. This evidence tends to prove that the fact is fact in issue and is determined by the rules of substantive law or the rules of court. Admissible evidence. Evidence is admissible if it is relevant to the issue and is not excluded by the rules of court. Credible evidence. Evidence is credible if it is not only admissible evidence but also believed and used by the court in deciding cases. Collecting physical evidence. All items are were found. Lesson 3. Collecting, marking, tagging, and preserving evidence. Collecting physical evidence. All items that were found in a crime scene should be collected. And the proper actions to be done on specific kinds of evidence in the scene are irrelevant. Blood is an important evidence in homicide, assaults, robberies, or other cases where it may be spilled. Hair may be found anywhere in the crime scene. It is often found on the clothing of a victim and suspect who have come into physical contact with each other. Fingernail scraping. In case in cases where physical contact has been made, fingernail scraping should be obtained. Rape cases, assault cases are good examples of cases where fingernail scraping may be important. Fiber. It is excellent as tracing evidence when clothing cross contamination takes place. This is also important evidence in robbery and hit and run cases. Glass. It can be important evidence in robberies and hit and run cases. It may be found as a trace evidence in robberies and hit and run cases. It may be found as a trace evidence in clothing and shoes. Prosecutors will examine to determine if both the evidence example and the non-standard has the same physical properties and trace elements as in impurities. Firearm. Are bullet, shotgun bullet, shotgun pellet, and wad. Explosive residue and gunpowder pattern can provide vital evidence and specific answers to possible question in case. Bullet. It can provide information about ala, nawala. Ano? It can provide information about the make and type of ammunition and weapon from which the bullet was fired and whether or not it was fired from a specific weapon. Provided the weapon is available for test purposes. Cartridge case. This can also provide vital information as the type of weapon used, the type of ammunition, and whether or not the case was fired in a specific weapon. Seminal stain. It is often, but not always, found on clothing, blankets, sheets. It is also biological evidence like blood. It must be collected properly to maintain its integrity. Marketing of physical evidence. As evidence collected it is individually marked with the initial of the investigator. The marking tool depends upon the nature of the evidence. Marking of firearms related. Revolvers must be marked separately on the barrel, frame, butt, cylinder, and stock. The tape should also be put around the bore of the frame, butt, cylinder, and stock. The tape should also be put around the bore and the frame of the gun with signature of the investigator. Pistols must be marked on the barrel, but magazines, and stock. Tape must be also be put around the gun with signature to avoid changing the parts of the gun that may affect the result of laboratory examination. Rifles. It should be marked on the barrel, frames, magazine bolts, or slide. All magazines and accessories should also be marked. Fire, empty shells, and misfired cartridge. It must be marked near in the mouth of fired empty shells, not on the body, peripheral surface, or base. Bullets, slugs, balls, and pellets. A bullet or slug can be marked on the ogive or nose, as well as in the base, not on the body-bearing surface. Tagging evidence. All evidence which, by their nature, could not be marked on each surface such as could not be marked on each surface, such as blood, hairs, fibers, and the like, are properly stored in an appropriate container. Preserving physical evidence. Perishable materials should be perceived along the way of the preservation is in order to reach the court in the same physical condition as when they were collected from the crime scene. It includes preservation of tool marks, preservation of controlled substances and medical preparations, preservation of question documents, preservation of plantain fingerprints. La- Three types of fingerprints that can be found in a crime scene. Plantain fingerprints are made of the sweat and oil on the skin's surface. Plantain fingerprints can be made by blood, grease, ink, or dirt. This type of fingerprints is easily visible to the human eye. Plastic fingerprints are three-dimensional impression and can be made by pressing your finger in fresh paint, wax, soap, or tar. Like patent fingerprints, plastic fingerprints are easily seen by the human eye and do not require additional processing for visibility purposes. Lesson 4: General Rules and Equipment in Processing Evidence. General rules in collecting and preservation of biological materials. Use protective gloves, avoiding coughing or sneezing materials. Packaging of biological materials. Special precautions. Materials for evidence, packaging, marking, and sealing. Acceptable packaging containers, depending on the type of the evidence, include paper bags, plastic bags. Clear plastic is preferred for drug cases. Boxes, study cardboard. Manila envelopes, small glass vials, typical arson or liquid drugs, metal cans, typical arson. Acceptable seals, tamper-proof evidence tape, reinforced packaging tape, heat seal. Information on each package should minimally include name of the agency case number, item number, date, investigator identifier. Additionally, packaging of evidence should include where the item was found, by whom, date and item found, description of item. Traditional methods of preserving or recording evidence: photograph, audio, and or videotape, microfilm, photostat, Xerox, voice tracing, etc. Photography is considered to be the most practical, useful, reliable means of preservation due to the following reasons. Sketching, if no scientific apparatus to preserve evidence is available, then a rough drawing of the scene or object to be perceived is done. Observation of description. Description is done by putting into words the person or thing to be preserved. Describing a thing requires keen observation and good power of attention, perception, intelligence, and experience. What is portrait parle? Spoken picture. Refers to verbal, accurate, and picturesque description of the identified, such as information may be given by the witness, relatives, or other person who are acquainted with the physical features of the person to be identified. If a skilled investigative illustrator is available, a picture of the person to be identified may be drawn as sketch. Cartographic sketch as a check out to the sketch or drawing made. It must be shown to the person who gave the information to see whether it tallies with the person to be identified. Mannequin method. In minimize model of the scene or of a human body indicating marks of the various aspects of the things to be served. Anatom- anatomical model or statue may be used and injuries are indicated with the appropriate legends. Preservation in mind of the witness, a person who perceives something relevant or proper adjudication of a case may be witness in court he or if he or has the power to transmit the others what he perceived. Written notes, what you have seen or observed. Developing and lifting fingerprints found at the crime scene. Gathering physical evidence, plaster cast, written statement of subject and witness. Integrity of evidence or trace. Integrity of trace evidence. Protection of trace evidence from loss contamination is essential. One of the primary paths is if contamination is from the collector of the evidence. What is the principle of chain custody? Evidence passes through a several person for several purpose. Due to this, the principle of chain custody must be observed. What is the chain of custody rule? It is of paramount importance to any investigation. It is an unbroken sequence of evidence that is caused by an item of evidence from the time it is found at the crime scene to the time it appears in court. What does chain custody do? The chain custody proves the integrity of piece of evidence. A paper trail is maintained so that the person who had change of the evidence at any given time can be known quickly and summoned to testify during the trials if required.